some of the benefits that we saw through a model law was that it would provide one uniform approach to conciliation. It would also provide some certainty in how a conciliation would be conducted, what role the courts would play, and where the parties or the conciliators would seek court assistance to support the conciliation process. Just briefly, and I'm really now running out of time, I think I have 5 minutes to go, so I'll just briefly go through the fact that the model law looks at the process rather than the name that the parties give it. It recognises that, for example, parties may call a dispute settlement method by another name, not conciliation but mediation or alternative dispute resolution. So it looks at the process and says if there's a third party helping the parties to resolve a dispute and that's not a binding settlement, then it'll be considered to fall within the model law. It applies irrespective of the basis upon which the conciliation is carried out, so it can be either by contractual agreement or by direction or suggestion of the court, but it won't apply if a judge or an arbitrator tries to resolve the dispute in the course of judicial or arbitral proceedings. The main aim of the model law is to preserve the principle of parties' freedom, because it was recognised that conciliation, the base of conciliation is always consent by the parties, and so that's respected in the model law. And essentially the aim of the model law is preserving principle of party autonomy, so the parties basically can decide how they want to resolve their dispute in conciliation, but failing that agreement, it's up to the parties to, the conciliator has the discretion to determine how to resolve the dispute and how to conduct the conciliation. And again, the focus is on trying to resolve the dispute, so the conciliator always has the power to suggest a solution at any time. One of the other areas dealt with by the model law is the duty of disclosure. A conciliator is basically obliged to disclose information that's received from one party to the other party, unless one of the parties gives the conciliator that information on the basis that it will be kept confidential. Again, the main aim is to preserve party autonomy. Another aspect of the model law is the general duty of confidentiality. In general, there's a duty that the conciliation should be kept confidential, but that's subject to a public interest exception and also subject to contrary agreement by the parties. Another area which was considered important to resolve in the model law was admissibility of evidence in other proceedings. Essentially, parties won't talk freely if they feel that the evidence they give is going to be used against them at some other later proceedings. So the aim here was to try and create a rule which would protect the leakage of this information in subsequent proceedings. And you have this information in your booklets, I won't go through it, but one of the most important aspects is that it applies not just to parties and conciliators, but also to third parties. It also deals with, in Article 12, the role of the conciliator. In general, the rule in the model law is that if you're a conciliator, you can't then later act in a related arbitral or judicial proceeding, obviously. This is subject to contrary agreement by the parties, because it was felt that sometimes there might be a situation where parties will actually want to resolve the dispute with the same person as the arbitrator that was the conciliator. And I've only got 2 more minutes, if you'll allow me that. One other aspect of the model law is that you can't resort to arbitral or judicial proceedings when a conciliation is on foot. This was basically aimed at preserving the idea that you really need to protect the conciliation process. If you are going to have a conciliation, you should have some way of stopping parties from going elsewhere while the conciliation was on foot. And lastly, which is probably the most important, I could talk about this for an hour, is enforceability of settlement agreements. Essentially, this is one of the most controversial and one of the most important articles in the model law. What it does is it simply says that the settlement agreement that's concluded by parties is binding and enforceable, but it leaves the method of enforcement to national laws because it was considered just impossible to try and find one method of enforcement. Currently, there's legislation based on the model law in Hungary and Croatia and in the US as well, which I've started to talk to with a representative of the US Department of Justice who's here somewhere. They've basically passed law which will implement the model law in respect of international commercial mediation. that's all I have. It's a potted history of the model law on commercial conciliation. If you want more information, it's probably best to start with our webpage, but you can also talk to me in the break. Thank you very much.